अच्छा।
Okay. Okay. Today's topic is hiring and supervision of professionals under IBC. As an insolvency professional, we frequently encounter various operational and strategic challenges during the CRP, liquidation, and other proceedings under the IBC code. One such critical area that demands both legal understanding and practical prudence is the hiring and supervision of professionals during the insolvency process. Under the IBC, the resolution professional or liquidator is empowered to appoint registered valuers, legal experts, accountants, and other professionals to support the resolution or liquidation process. These appointments are essential. As you know, these appointments are essential for the smooth conduct of proceeding, ensuring compliance, protecting stakeholders' interest, and maintaining transparency. However, with these powers comes responsibility, particularly concerning due diligence in selection, assessing necessity, ensuring cost efficiency, and monitoring performance. There are several judicial judgments and IBA regulations that outline the framework and expectation in this regard. Normally, question arise such as who qualifies as a professional under this code. What is the scope of the RP? RP's discretion in appointing them? What are the boundaries for incurring costs without COC approval? How should conflicts of interest be avoided? And what are the checks must be in place to ensure accountability and independence? These are not merely theoretical questions. They have real world implications. Improper appointment or supervision can lead to objections from COC, questions from adjudicating authority. They can also disallow fees or even personal liability of the IP in some cases. Today we will explore the topic in detail. I have prepared a PowerPoint presentation which I hope will offer clarity on the legal provisions, best practices, regulatory expectation, and case laws relevant to the hiring and supervision of professionals under the IBC code. So let's begin today's session. I will now share the PPT with you. Please confirm once it's visible on your screen. I think I have already shared PPT. Is this visible to everyone?
Yes, sir, it's visible.
Okay. Now let's start. Removal of hiring and supervision of professionals. In accordance with the provisions of the IBC code, is required to engage various professionals, including but not limited to registered valuers, accountants, legal advisors, and other experts to ensure the effective conduct of the CIRP and liquidation process or any other process under this code. Actually, in normal terms, registered value have are to appoint registered valuers, accountants, and legal advisors. So, for the purpose of smooth CRP process and liquidation process. This document lays down the principle, procedure, and responsibilities for the hiring and supervision of such professionals in a fair, transparent, and accountable manner. When any resolution professional is going to hire any professional, he must be fair and transparent because at the end of the day he is also accountable for this hiring, because if he will not hire the professional person means as per the business requirement, then he will also face the challenges, and he is also responsible for COC and adjudicating authorities. The what is the objective? The objective is to ensure that all professionals engaged contribute meaningfully to the insolvency resolution or liquidation process while maintaining independence, confidentiality, and compliance with applicable laws and regulations and ethical standards. Whenever any person we are going to hire, we need to see he must be independent, no related party, no related to insolvency resolution professional, and that person will have to maintain the confidentiality, and also we will have to adhere the applicable laws or compliance under the IBC code. Now, the hiring process shall be merit basis, cost effective, and in the best interest of the stakeholders of the corporate debtor. Whenever any resolution professional is going to hire any other professionals, that hiring must be on the merit basis. Actually, we should not we should not and we can't hire a professional if we know any person and then we are offering to join. That is not the right criteria. The hiring must be on the merit basis and also cost effective. In this manner, what we can do, we can, for example, if we are going to have any professional, so then we will see what our business requirement. According to the business requirement, okay, we need to hire any professional as per the and as per the relevant compliance under the IBC. The hiring process shall be merit-based, cost-effective, and in the best interest of the stakeholders of the corporate debtor. The supervision of professionals shall be conducted diligently to ensure that their output meet the standards expected under the code and the directions of the adjudicating authorities and the Insolvency Bankruptcy Board of India. Okay. Whenever we have hired any person, definitely we will share what will be their KRA as per the business requirement, as per the means compliance under IBC. So we will have to follow up and that person will have to meet that criteria unless until he will provide the output on time. So then ultimately our CRP liquidation will effect. This framework is intended to reinforce the fiduciary responsibility of the insolvency professional in the conduct of the process and safeguard the integrity, objectivity, and efficiency of proceeding under the IBC. Okay, means if IP is means hire any person on merit basis and cost effective and he is fair and transparent, so then he can also safeguard the integrity and that IP can also means get the objectivity and also efficiency of the proceeding under the IBC. Introduction of hiring and supervision of professionals under IBC. The IBC code establish a time-bound and creditor-in-control framework for resolving insolvency of corporate persons, partnership firms, and individuals to ensure the smooth and efficient conduct of proceedings, such as corporate insolvency profession, CRP, and liquidation, voluntary liquidation, and bankruptcy process. Insolvency professional is empowered to appoint a range of professionals, including registered valuers, legal counsel, chartered accountant, company secretaries, cost accountant, and other experts as may be necessary. As per the business requirement, he is authorized to appoint professionals and he is empowered to appoint such professional who may and will help in the process, CRP process and liquidation process. The role of these professionals is critical in assisting the IP in carrying out his or her statutory duties. Their services may be required for legal representation, valuation of assets, forensic audits, sectorial work, financial reporting, and other process-related tasks. Ultimately, insolvency means resolution professional is responsible for hiring those persons, but he will have to take also approval from the COC. Ultimately, he is the person who will supervise the professionals' work, so that he can ensure that other professionals are doing their work as per means as per objective, as per timeline. So these things comes under the purview of insolvency professionals. And we will also understand all those things with the help of the judgments, relevant judgments. Okay, now introduction for hiring and supervision of professionals under IBC. The selection and management of such professionals must adhere to principles of transparency, objectivity. Number one, transparency. There must be a transparency. Means the process and candidate at the time of hiring, the process must be transparent. Okay, it should not happen ki I am hiring any known person. Okay, and means that will not meet the objective. We can, we should hire any professional on the merit basis. Okay, but it should not happen if I know the person. Okay, I'm simply approaching that person and asking to come means for these smooth operations is which RP is handling CRP or liquidation process. It should not happen. The process must be transparent. Okay, and there must be objectivity. Okay, there must be any objective. Why we are going to hire any professional? There will be any objective. For example, if there is a registered value, if we are going to hire, so there is a means mandatory requirement as per under IBC for CRP and liquidations. Okay, but when we are going to hire any other person, professional, so there will be objective. For example, if we need help for legal counsel, if there are so many cases going on for the that particular company, which RP is going RP is handling that company, so then he will have to hire the counsel if he need the help of counsel, because he cannot handle or manage the legal activities, legal cases. He will have to hire any counsel. So means there must be any objectivity. Okay, now next question comes: who will be accountable? No doubt that particular professional will be accountable, but at the end of the day, ultimately the resolution professional is responsible because he will have to review their work. Okay, so he is also accountable. And next question comes cost efficiency, because ultimately the objectivity of the CIRP is to means value maximization of the stakeholders. We need to see what is the business requirement. As per business requirement, we will hire other professional on the merit basis. Okay, for example, if I'm going to hire any means company secretary, okay, or any cost accountant, so we will have to see what are the scope of work. As per the scope of work, as per the industry norms. Okay, so then on that basis we will hire that professional. We will not hire the means on higher cost, means more than market basis. We will have to consider the business requirement. According to the business requirement, we will have to take decision. The selection and management of such professionals must adhere to principles of transparency, objectivity, accountability, and cost efficiency, and be aligned with the over overarching objective of value maximization of stakeholders. In the context of the IBC, has also issued various regulations and guidelines to ensure that the hiring of professional is done in a manner that is free from the conflict of interest. Okay, now that is the very critical point. Whenever any transition professional is going to hire any other professional, that must be there should not be any conflict of interest. If that professional have any interest in this in this company or in that organization, and is then there may be chance of conflict of interest. So then that hiring must be free of conflict of interest and ensure the independence and competence of the appointed experts. Means there must be an independence. For example, if that person is not in relation or related party with that company or with the resolution professional or with the directors, means that professional person is free from conflict of interest and ensure the independence and competency of the appointed expert. That is the very critical and crucial aspects which we need to take care whenever we are going to hire any professional. Otherwise, what will happen if we will hire a wrong person? So then what will happen? Then ultimately, resolution professional will suffer, and COC will also raise question, and maybe he will not approve. means we will not approve the post, and educating authority also can raise the question. So then there must be that resolution professional must be competent for that particular task, for which purpose any resolution professional is going to hire that person. This document outlines the procedure. Okay, we need to clearly define the what will be the procedure. Okay, how we will hire that person. There must be a certain procedure. Okay, and we also need to define the responsibility. Okay, for that professional person which we are going to hire, and compliance obligations. For example, if we are going to hire any legal counsel, so then he must be registered with any bar council. If we are going to hire any company secretary, if we need any practicing company secretary, he must have a CPA, means and if we are going to hire any if he is not having CP certificate, and we need to hire any means professional agency, CS professional agency for the fulfilling of the compliance part. So then that these things also need to check by the resolution professional. Means these document outlines the procedure, responsibilities, and compliance obligation for the hiring and supervision of professionals by an insolvency professional in accordance with the provision of the code, the relevant regulations, and the direction of the educating authority. Okay, means whatever and whichever the requirement defined by the IBC under the IBC code, under the IBC rule and regulations, and also the direction of educating authority, we need to adhere the proper procedure. And whenever we are going to hire, we can also means definitely define, first we define this scope of work, and we will hire that professional persons as per the business requirement, but as per the compliance obligation under the IBC code, and also as per the direction of the educating authority. So we need to take care. These things are very crucial. Means there must be transparency, there must be objectivity, clearly defined accountability, and also cost efficiency. Okay, and when we are hiring, when we will release any document, so that document clearly must be defined the procedure, responsibilities, and compliance obligations. Okay. So what will happen when we will clearly mention the scope of work, then there will not be any conflict, and there will not be any confusion. And we also need to define the timeline. Okay, now coming to the definition and classification of hiring and supervision of profession under IBC code. Now we will discuss what are the rule and regulations under the IBC code. Okay, in CIRP, in liquidation. Then we will discuss in detail the relevant judgments related to supervision of hiring and supervision of professional under IBC. Okay, now now the definitions we will discuss under the IBC and its associated regulations. Professional refers to individuals, any individuals or any entity. Okay, we can hire any individuals. For example, if we need registered value, we can hire any individual. Okay, if we need any agency, for example, means CF firm, CS firm. Okay, so we can hire either individual or any or firm or any entity possessing specialized knowledge, expertise, and registration under applicable laws, who are engaged by the insolvency professional for the effective conduct of insolvency, liquidation, or bankruptcy process. Okay, we have already discussed specialized knowledge, expertise, and registration under applicable laws. What it means? It means if we are going to hire any registered value, so that registered value must be registered with IBBI. Okay. And if we are going to hire any counsel, that person must be registered with bar council. Means these persons, and if we are going to hire any CS, then practicing CS, so then that professional person must have the CP. Okay, so these are the things need to take care by resolution professionals when resolution professional is going to hire any individual, any firm, any entity, that person or that entity having the proper registration with under the applicable laws or not. If that firm or that person is not having, for example, if we are going to hire registered valuer, if he is not means registered with IBBI, so then it's then professionally or means as per law, as per IBC code, so we cannot hire. Okay, if we will hire, so then professional means that resolution professional will be liable for this hiring. Means we cannot hire. These things will have to take care by the resolution professional. Now, for this effective conduct, okay, now these professionals assist in IP in carrying out tasks that require technical, legal, financial, or management. Sometimes resolution professional need any technical person. Okay, because this resolution professional have to hire registered valuer for SFA, for plant and machinery, for building, for any other purpose. If he need any technical person, means as per means the unique business, so he can also have, and he can also have any technical person, any legal person, any financial or any managerial skill person as per the business requirement, and but under the IBC rule and regulations. Okay, or rule and regulations by IBB. As per regulations, okay, 21 EA, subsection 2 EA of the resolution process for corporate person regulation 2016, a professional means a person or entity whose services are required by the resolution professional or the liquidator to assist him in the discharge of his duty under this code. Okay. So in this regulation, it's clearly defined कि insolvency resolution process. Okay, means resolution professional can hire a professional, to then who will cover under this definition professional, that professional person who can assist him in the discharge of his duty when he is doing CRP or liquidation process. Okay, so it's clearly defined. Means as per these regulations, RP empowered to hire any professional whose services are required for the purpose of CRP and liquidation. Okay, during that process to assist him. Okay, in the discharge of his duties under this code. Now, define and classification of hiring and supervision of professionals under IBC. Okay, we can also classify key how type of legal means professionals we hire. Okay, see, if classification professionals hired under the IBC framework can be broadly classified as follows: legal professional. Okay, advocates, when we are going to hire any legal professional, the resolution professional will also check advocates enrolled with bar council, law firms providing legal advisory, litigation or compliance services. Okay, so whenever means we need to hire legal professionals, so that that individual or that firm can assist in resolution professional, okay, in the process of CRP or liquidation. Okay, so then as per business requirement, he will definitely share the KRA as means the scope of work. Okay, and on the basis of scope of work, they will ask and negotiate, okay, for the fees, and on the merit basis and as per the business requirement, resolution professional will hire legal professional. Okay, now coming to the second, now we also resolution professional also have to hire registered valuer. Okay, so registered valuer with the IBC code must be registered with IBC. under the company's register evaluation regulation 2017 required resolution professional required registered valuers for assets, land and building, plant and machinery, security and financial assets. Okay, means during CIRP and liquidation process, we have to means insolvency professional have to hire legal professionals, registered valuers, and also other different type of professionals which we are going to discuss. Okay, now coming to the third one, definite financial experts. We also need to hire for financial activity if books are not closed, and we need means for accounting purpose. And if that firm is in manufacturing, we also need to means complete the means post reports, and also need to take care of the cost means post compliances. So we need to hire for financial purpose. We need to hire for taxation purpose. We need to hire chartered accountants. For if that company or that firm is manufacturing concerned, then we will have to hire also post accountant, so that resolution professional can also means do relevant compliance on time. Okay, and with the help of these professionals, means post accountants, if and other financial consultants, typically assist in audit. Okay, if there is a audit, forensic review, accounts preparation, and transaction in review, so we need to hire financial experts. Okay, these persons helps only in means financial part. Okay, financial and posting part. Now coming to another point, company secretary. Qualified company secretary who assist in regulatory compliance, documentation, filing of forms with ROC, NCLT, and conducting meeting of the COC. Means they can also help in conducting meeting of the committee of directors, because that company have to update the reports and details, and means MCA compliance. So in that case, we need to hire qualified company secretaries. Okay, so then when we are going to hire any qualified company secretaries, then resolution professional at least need to confirm, check, and verify whether that individual person or that firm is registered with the institute in that and having CP, certificate of practice. Okay, so that is the legal requirement. Okay, because unless until that individual person or firm is don't have CP certificate, then they will not be able to help you, because they will not even least upload the documents, and legally they are not authorized to these activities unless until if we are not having the CP. Now coming to the another, there is a technical experts. Okay, we also need to hire technical experts. Engineers, environment consultants, IT experts, or any other specialist whose domain expertise is relevant for evaluating or operating the corporate debtors business. Okay, if that organization, that company is in manufacturing company. Okay, if we need data or detail for the purpose of means I will give example. For example, for registered valuer, if they are doing valuation, so they need also need the data. Okay, so in that case, if there is no engineer in that company, if we need miss any specialist, so then resolution professional can also hire technical expert. Okay, who are expert in their domain, and who can assist in the process of CRP. And but again, I'm telling the main point is this: we will hire as per the business. If there is a requirement, if there is no requirement, then we will not hire. If that firm is already having the engineer, okay, and environment consultant and IT experts already in that company, so then we don't need to hire. Okay, we will hire those persons unless until we don't have that expert already in that company on the role, or means in the business. Okay, and as per the business requirement, we will hire. Okay, but as per the approval of COC and as per the direction of the educating authority. Okay. Now, process advisor and transactional auditors. Another type of professional we need to hire. Experts engaged for due diligence, information memorandum preparation, monitoring control mechanism, or detailed transaction audits. Okay. If resolution professional need any professional for the purpose of process advisor or transactional auditors, so he have to hire those professionals as per the business requirement and as per the rules and regulations under IBC. Okay. Now coming to that. Okay. Now, see, earlier we have discussed ki how many type of classification is there of professionals. And means point number two, legal professional, registered valuer, financial experts, company secretaries, technical experts, and sector specialists and process aware. So these are the types of professionals we categorize. Okay. The majorly we categorize these type of the professionals we need to hire, and we normally we hire. Okay. Now coming to the what will happen after hiring. If you have a resolution professional hired the professional, okay, so then next step is if we will have to supervise of the professional's activity or work, because at the end of the day we need that detail and that document. Okay. And the as per the purpose of the purpose of hiring and the as per the objectivity, and also to meet the deadline, because CRP and liquidation is a time bound process. If we will not supervise, okay, if he will not provide, that professor will not provide the data detail document as per the scope of the work, ultimately we will not be able to meet the deadline. And CRP and liquidation is a time bound process. So that's why the supervision of professionals is very important and critical. Okay, under IBC and for the purpose of CRP and liquidations. Okay, now the supervision of professionals engaged under IBC involves first, due diligence at the time of selection, ensuring qualifications, independence, and absence of conflict of interest. Okay. First of all, we will resolution professional will have to do due diligence, because he will ensure ki what are the basic requirement of means that professional for hiring for particular that task. Means he will have ensure qualifications. If I need any professional person for the purpose of MCA compliance, okay, so then I will have to ensure that person must be CS. Okay. And another is independence. That person must be independent, not related to that person must not be related party. Okay. And also absence of conflict of interest. Okay. If that professional person is having any interest in this company or any relationship with promoter, director, okay, means having any interest in the business, so that person cannot be hired. Okay, so that person must be from absence of conflict of interest. So that is the first criteria. Okay, now defining scope of work, that is very important, that is most important. Defining scope of work clearly through engagement letter or contracts. Okay, we need to means share or mention everything in the scope of work. Clearly mention in the engagement letter what is expected. Okay, and what will be the scope of work. Okay, and also with the scope of work, we need to mention the timelines. Okay, if we will not mention the timelines, then what will happen? He will take very much time and he will not provide that detail or work on time. So ultimately it will impact the CRP. Okay, so then resolution professional will have to means complete all the tasks, all the things in time bound manner. So then for that purpose, we need to issue scope of work to the professionals with clearly mention everything in the engagement letter clearly, so that we can also avoid any conflict of interest or any confusion. Okay. Now monitoring and evaluating deliverables and timelines. Okay. On regular basis, resolution professional have to or should monitor, okay, and also evaluate the deliverables, okay, as per the scope of work, okay, and timelines. If that thing happen or as per scope of work within timeline or not, otherwise it will impact on the CRP and liquidation process. So that is very critical and important. And other side also, professional person also need to complete their task on time. If that professional person is facing any challenge, so he should come out means before time, and so raise the question so that resolution professional can help. Okay, if that professional person is not getting data from the means from COC or any other person. Okay, so then if he need to discuss with the resolution professional so that he can help. Okay, it should not happen ki when deadline is at the end point and he is raising question ki that person didn't get anything. For example, for if registered value is to do valuation, so he will have to do valuation within time frame. Okay, if he is not getting data detail from any means concerned person, so then he will have to take action. He will have to discuss with the resolution professional. He will have to take means appropriate action so that he can complete their task on time. Okay, so for that purpose, resolution professional is also responsible. Okay, for monitoring and evaluating the deliverables and timelines. Okay, now coming to ensuring compliance. Okay, with the code, regulations, and directions of the Committee of Creditors and Adjudicating Authority or IBBA. Okay, the resolution professional is also responsible to ensure all the compliance. All the compliance means with MCA, with IBBI, with NCLT means educating authority, okay, with COC, okay. Ultimately, he is also a means court officer, and he is reporting to educating authority, okay. So means he is responsible for ensuring compliance. If he face any challenges, so then he should take appropriate action, okay. If there is problem with the COC, so then he can approach to educating authority for appropriate direction. But ultimately, the resolution professional will be responsible for ensuring compliance related to that organization. Whether that is related to means MCA, whether that compliance is related to taxation, whether that compliance is related to IBBI, whether that compliance is related to adjudicating authority. So he is ultimately responsible for to ensure compliance. Okay. Now coming to next, periodic review and reporting. He should prepare such type of process. So and also he need to review periodically. Also there he should also ensure means proper process or proper reporting process so that he all the concerned person can get the reports and everything what is required as per under IBC. All the stakeholders can get that information detail or document, okay, on time, so that resolution professional also can meet the deadline means timeline, okay. Periodic review and reporting, including submission of invoices and progress reports subject to verification and approval. Okay. And it means he is also responsible for submit various progress reports, preliminary reports, so many reports. Okay, and he should also take means detailed reporting and of all other professionals. Okay, so that he can also submit their reports to adjudicating authority and also can take appropriate action on time. The IP remains personally accountable for the performance of the professionals and must ensure that their engagement is justified, necessary, and cost effective. That is the bottom line. Okay. IP, insurance professional, will remains personally accountable for the performance of the professionals. He cannot say and means ki I am not responsible. Ultimately, IP is also responsible. Okay, for their performance, because if other professionals are not means performing and doing means their task, so then he should raise question and take appropriate action. Okay, if he is not taking action and the CRP timeline will also impact, so then he is also personally accountable for this, and he must ensure that their whatever engagement done by insolvency professional, okay, is justified. Okay, what it means justified means as per the business requirement. If there is a business requirement, that it means it's a justifiable. Okay, as if business requirement means if that professional person is not in the system, okay, and he need any professional expert, okay, to assist in the CRP liquidation process. So, means there is a justification, there is a requirement. If there is no requirement, he should not means again any person. Means sometimes what happen, there may be chance if any reservation professional is hiring means without any means task, if there is no requirement, if any person is being hired, so then that is not means correct. In that case, COC can also raise question and maybe not approve, and educating authority also can raise question and ask and take appropriate action. So then I response means I insolvency professional is personally accountable. He need to ensure that hiring is justified, okay, and there is a necessity, means necessary, and also a cost effective. Okay, this cost effective means as per business requirement we need to hire means professional. Okay, means we should not hire a person on higher side. Means if that professional person is available on X amount, so then we can give means X plus 0.1, X minus 0.1. It should not happen if we are giving X 200%. So that is not cost effectiveness. So then we need to take care cost effectiveness, necessary, and also justify. Okay. Okay, now what are the provisions as per the IBC code? Okay, now we will discuss in detail. During CRP process, provisions under the IBC, section 22A, management of operations of corporate debtor as a going concern. Okay, whenever there is a CRP process means we do and go this process as a going concern process, means that concern will go. We are not going to sell their assets. We will not liquidate that firm. That is the assumption when we are doing CIP process. Okay, means as per section 22A, the main criteria is management of operation of corporate debtor as a going concern. Okay, in liquidation, what happens? We sell the assets. Okay, and we ultimately close the business. But in CIP process, our intention is to revive the business. Okay, not to close the business. Okay, if we are not in position to revive the business, then further step is liquidation. Okay, but first step, as you know, revive the business. So that means that is based on going concern basis. As already we have already studied in accounting. Okay. Now, the IRP is responsible for ensuring the corporate debtor continues as a going concern. The section authorizes the IRP to appoint accountants, legal or other professionals to protect and preserve the value of the corporate debtors property. Okay. Means as per section 22A, empower insolvency professional to manage the operations. Okay, okay, on the basis of going concern. Okay, when resolution professional is managing the operations of corporate debtor on the basis of going concern, if there is a requirement to appoint professionals, he is empowered to appoint professionals like accountants, legal counsel, technical person, registered valuer, okay, and any other professional as per the requirement, okay, under the IBC code. But this is the section 22A says hiring of the person because insolvency professional is managing the operations of corporate debtor on a going concern basis. Okay, but the purpose facilitates expert support for managing the company during CR. Okay, the purpose of hiring of any professional is to support for managing the company during CRP process. And who means is responsible for CRP? Insolvency professional is responsible for CRP. Okay, so now this is the provision 22A. Okay, now we will discuss all the other provisions now. When we have hired in CRP as per regulations above, we discussed 20. Now section 225 2D, okay, says duty of resolution professional. Okay, earlier we have discussed key means in detail, but now we are discussing with the proper section and rural regulations, relevant rural regulations related to hiring and supervision of professional under IBC. Okay, now section 25 2D, duties of resolution professionals. The resolution professional RP must take steps to preserve and protect the assets of the corporate debtor, including in continued business operation. Okay. Now, what is the duty of resolution professional? Resolution professional must take steps to preserve and protect all the assets of the corporate debtor, including continued business operations, which empowers RP to appoint professionals to assist in performance of his duty. Okay. Now, the purpose ensures that specialized skill are available to support effective resolution. Okay, means the purpose is to ensure that specialized skill means the professional which we are hired will help us and support us for effective CRP and CRP process. Okay. Now coming to regulation 27. Okay, appointment of professionals. The IRP and RP may appoint professionals as may be necessary. Appointment should be justified in terms of necessary and qualifications. A letter of engagement or contract. We will also discuss in detail engagement and contract letter, which I have already means mentioned here in PPT. What we should cover in engagement letter or contract letter when we are going to hire any means professional. Okay, now coming to IRP and RP may appoint professional as may be necessary. Appointment should be justified in terms of necessity and qualifications. Okay. Now, a letter of engagement, a contract must be issued defining scope, fees, and deliverables. Okay, this thing we already discussed, but main focus under the Regulation 27 is this: ki whenever any regulation professional is going to hire any professional, okay, he will take care the what is the necessity and also the qualification as per the required qualification. Okay, and a letter of engagement. Okay, letter of engagement must be defined scope. Okay, that is very important to avoid any conflict of interest in future. What will be the fees? And fees will be based as per the scope of work. Okay, and also fees can be decided on arm length basis. Okay, defining scope, what will be scope of work, and fees will be on the basis of scope of work and deliverables. Okay, it should not happen. We have given engagement letter or contract with any professional or any agency without deliverable. It will not solve the CRPL limitation purpose. So then we need to hire any before any appointment professional, we need to issue engagement or contact letter defining scope, fees, and deliverable. Okay, now what are the key points here? We need to see take care. Maintain arm length relationship. Okay, for example, for if I'm going to hire any professional, okay, and as per the scope of work, we can take quotation from other agencies also. Similar type of agencies. Okay, and if we are hiring any professional, okay, for any agency, so we can say ki how much will be the cost and how much will be their fees, cost plus fees. Okay, so then we can set fees on arm length basis also. Will also okay. Selection must be transparent. Okay, there must be a transparency. Everyone knows ki what was the process. Okay, means if there was a process, if first we will issue the means the requirement of that technical person. What should be the requirement? For example, if we need legal counsel, so then we will issue means document mentioning we need legal person who is having the that much experience and in this relevant field, means for example handling IBC matters. Okay, these are the things we will have to mention, and we will have to be transparent so that there must be transparency. Okay, so that another person cannot ask any question. If he has asked what was the process, so then we can define. And if any means adjudicating authority also can ask what was the process, on what basis you have hired that professional individual or means agency. So then we can also share and produce the document. What was the process, on what process we adopted to hire that resolution, that professional. And also non-discriminatory. Okay, means for example, if there are 4 person, okay, approached on the basis of that document we company issued, we need hire that individual, and if we know 1 person, so that should not be the criteria. Okay, everything should be on the merit basis. Okay, merit basis means as per what is the qualification. First, what are our requirement? What are the fees which they are asking? Okay, it means on merit basis we will select the professional. Okay. Fees must be reasonable and justifiable. Okay. Means reasonable and justifiable we have already discussed. Means adjudicating authority can also ask question. COC can also ask question. On what basis you have decided fees? If I am going to hire any agency, okay, so then I will take means quotation from three different agencies. So that will be base. That is the means these are the quotations. Three different quotations from three different entities. Okay, on that basis we have negotiated the fees. Means fees must be reasonable and justifiable. Okay. Regulation. Fees of professional introduced to promote reasonableness and accountability in fee structures. The IRP must ensure the fees of the professionals are proportionate to the task performed and aligned with the market. Okay. We have already also discussed the proportionate to the task as per the scope of work, as per the requirement, whatever the task we have given. On that basis, on the basis of those tasks that professional will perform. Okay, the fees must be aligned with the market. Whatever the fees in the market for similar means activity, another companies are giving. So on that basis, we can set. Okay, after negotiation, we can fix the professional fees. Compliance requirements. COC may scrutinize and ratify the fees. Okay, ultimately we have to take approval from COC. Okay, so then they can also ask and scrutinize if COC finds ki we have hired that individual firm or individual person more than the market rate. And for example, if a particular task we can in normal fees of that task is say 2 lakh rupees. Okay, and we have hired any agency and giving 5 lakh. Okay, 4 lakh. So then COC can ask. Okay, so then there may be question from COC. Okay, then in that case, COC will not approve the fees. So then there will be a problem. The fees report should be maintained and disclosed to stakeholders. Whatever fees we have negotiated, there must be a proper document. Okay, there must be a proper base. Okay, if that fees will be as per market norms, okay, so then that fees will be justifiable. On that basis, we can justify the fees, and then there should not be any problem to approve fees by COC, and educating authority also can means will not ask any further query or question, and also there will be approval from adjudicating authority in case COC not approve. Regulation for means, and the another regulation is 33 subsection 3 and regulation 34 subsection 3 post during CIRP. COC is not constituted. The applicant financial creditor bears the IRP expenses subject to the approval by adjudicating authority. Okay. If COC is there, then resolution professional will take approval from COC. Okay. In case if COC is not constituted, so then definitely financial creditor will bear the IRP cost. Okay. And subject to approval by adjudicating authority. Now, what regulation 34.3 says, RP expenses, including professional fees, must be approved by COC as insolvency resolution process goes. Okay. The purpose COC has authority to ratify and oversees professional expenses. Okay. So see, these are the two different regulations, 33.3, 34.3. Okay. In case COC not constituted, in case COC constituted. If COC is constituted, then definitely the approval will be taken from COC. Okay. And if COC is not constituted, then financial creditor will bear that cost subject to the approval of adjudicating authority. Okay. Now we are discussing the rule and regulations and sections for the purpose of hiring and supervision of professional under IBC. Because when we, for example, if in case if there is any conflict, any confusion, so when we are approaching to educating authority, so then we need to mention, and then we need to clear. We also need to know what are the relevant rule and regulations related to hiring and supervision of professional under IBC. Unless until we don't know what are the section rule and regulations, so then how will we justify under which rule and regulations IRP empowered. So these are the rural regulations. Every resolution professional must know when there is a requirement of hiring and supervising of professionals. Okay. Now, regulations related to liquidation process. Okay. Provision under IBC code 2016 section and under liquidation process. What are the relevant sections related to hiring and supervision of professionals? Section 35 1 C. Okay. Powers and duties of the liquidator. Okay. The liquidator may appoint one or more registered valuer or other professionals to assist him in the discharge of his duties. Okay. Scope includes valuation, sale of assets, legal advice, audit, forensic analysis. Okay. Now, section 35 1C. Liquidator have to appoint registered valuer in case of there is the assets. Okay. So, and also need to hire other professionals to assist to discharge his duties. Okay. For example, if we are to sell the assets, unless until we have a valuation, then we don't know what is the actual fair valuation. So on that basis, decision can be taken by COC. Okay, means to then means liquidator or adjudicating authority can take appropriate decision and action. So then we need to hire registered valuers. Okay, for legal matters, for legal advice, we need to hire legal persons for audit. Okay, because if company is in liquidation or CRP, we need to means do other compliances also. So that and as per under this section, liquidator can appoint professionals. Okay, now in case that section is relevant to the liquidation process. Now there is a regulation 7 under the liquidation process. The liquidator shall report in writing the need for appointment. Okay. In case if liquidator appoint any person, so then the registration professional will have to maintain record in writing what was the need of that appointment, maintaining a register of professional with the details such as name, scope, fees, timeline, ensure independence and no conflict of interest. Okay. Under these regulations, the registration professional will have to maintain report in writing. Okay. And the detail need to maintain in the name of register of professionals in this register or in this means record. The record or detail will be maintained. What was the name of that professional person, that agency, address, and means what is their membership number, he is registered with Bar Council or CS. Okay. And what was the scope of work? Okay. What was the fees? Okay. And also what was the timeline? Okay. And timeline means what was the timeline and what and when that professional person or that agency delivered also need to means maintain in this register. Okay. Ensure independence and no conflict of interest, and also need to ensure by resolution professional that professional person must be independent and there must not be any conflict of interest. If that person is not independent and there is a conflict of interest, so then we will not liquidator cannot hire or appoint that professional. Okay. And another is transparency mandate. Maintain record for audit and stakeholder inspection. Okay. If liquidator appointed any professional person and he is maintaining that record, okay, and that maintain should be open. Means open means he will maintain that record for audit. If in case of if there is any audit requirement, okay, and stakeholders inspection, if any stakeholder want to inspection for this hiring, so that person, that stakeholder can also do audit, okay, for this hiring with the help of that register or that data or that detail. Okay, so there must be a transparency mandate. In this transparency mandate, audit and inspection by stakeholder is always open. Okay, if the stakeholder found there is any means any issue, any objection as per means not fulfilled as per IBC or relevant means compliance not done, so then they can take appropriate action. Appropriate action means they can take action means they can go to the adjudicating authority. Okay, they can also take action. So that for that purpose, registered professional must be transparent for hiring any professional. Okay, also need to see that person qualification is matching the criteria with the scope of work and as per the business requirement, and the fees is on as per market basis. Okay, and also the activity done by that professional in on time and on for that purpose, relation professional or liquidator definitely will monitor and follow up and review reports or means on predictable basis on time to time. Now, another regulation is 30. Consultation with stakeholders allows liquidator to consult stakeholders, secure creditors, shareholders when hiring professionals. Okay, so regulation 30 also give means one authority or one right to the liquidator. He can also approach to secure creditors because ultimately in COC meeting, COC or in CRP, okay, and also means these secure creditors shareholders are also these are the stakeholders. Okay, so he can also consult. Okay, true consultation is not binding; it stands transparency and confidence. Okay, see, he is not liable. For example, he can consult. Okay, he can take advice, but he will take appropriate action as per the requirement. He is not bound to do the further action or further step as suggested by these stakeholders. In case if he found that is not not as per the business requirement or as per under IBC, whatever may be the reason, okay, not personal reason, but on the basis of business requirement or business decision, he can take decision. Okay, the means the stakeholders consultation is not binding. Main criteria is this: he can take consultation, but that consultation will not bind on the decision of the resolution professional. And why resolution professional should discuss and consult with stakeholders? The purpose is mainly transparency and confidence. If he will discuss and consult with the stakeholders, so they will also think, they will also it will also come in mind कि everything is okay. Okay, and if they will have in such type of confidence, so then they will not ask any further query or any question. Okay, so then it will be good for resolution professional to consult with the stakeholders before hiring any professional. So what is the best practice? Through note, mandatory consultation enhance credibility and avoids disputes. Okay, that is the best practice. Okay. Now coming to liquidation cost. Okay, professional fees from part of liquidation cost under Regulation 2EA. Regulation 34, as per liquidation cost, professional fees form part of liquidation cost under Regulation 2E. Cost must be met from proceeds of assets realization and have first charge on distribution waterfall. Okay, what are the implications? Prioritized payments of hired professionals must be reasonable and properly documented. Means when there is a when we are calculating liquidation cost, the professional fees will be the part of the cost liquidation cost. Okay, and cost must be met from proceeds of asset realization. Given asset, there will be asset sale or asset realization. Okay, so then they have the first charge on distribution waterfall. Actually, there is a waterfall mechanism. Under waterfall mechanism, the liquidation cost is and have the first charge on the distribution. Okay, when after realization of or after proceeds of asset realization. Okay, now what is the implication? What is the prioritized payments of higher professional must be reasonable. Okay, so that must be reasonable and properly documented. Unless until it is properly documented, you will not be able to justify. And if you will not be able to justify, then COC or educating authority will not approve that fees, and then there will be a problem for means resolution professional or liquidator. So then, for that purpose, there must be a transparency, there must be a reasonability, there must be a documentancy. Okay, so these things need to take care by the resolution professional or liquidator. Okay. When hiring of any professional and supervision of professionals. Okay. Now, now coming to the voluntary liquidation. In voluntary liquidation, there is a regulation 7, which what says appointment of professional. The voluntary liquidation regulations. Similar to regulation 7 of liquidation process, liquidator can appoint professionals as needed. Okay. He is also means see there is a CRP, there is a liquidation, there is a voluntary liquidation, but voluntary liquidation rule regulations for hiring and supervising of professionals is more or less related means similar to the normal liquidation. Okay, now liquidator can also appoint professional as needed as per the business requirement. Okay, must ensure competency. That individual person or agency must be competent as per the means relevant laws as per under IBC. Okay, and there must be independency and reasonability of fees. Now we will discuss. Now we have discussed the we should take care by resolution professional or liquidator hiring and supervising of professionals. Then we discussed what are the relevant rules and regulations and sections related to CIRP liquidation or voluntary liquidation. Okay. Now we will discuss in detail. There is a recent amendment. Okay. The circular issued by the IBBI. Okay. So these amendments are very means critical and crucial. We must know, because if we are going to hire any professional, okay, this is very means relevant and must be adhere. Otherwise, we will not be able to do compliance as per IBBI. Okay, now coming to this, the IBBI circular number IBBI IP 005-2018, dated 6th January 2018. Okay, what was the title? Title was Appointment of Professional by Insolvency Professional. That was the title. Okay, lays down fundamental principles governing the appointment of professionals, such as valuers, auditors, legal advisors, and forensic experts by insolvency professionals during the CIRP resolution post and liquidation process under the IBC code. This circular seeks to promote integrity, independency, and transparency in professional appointments and eliminate conflict of interest, especially when significant insolvency resolution costs are involved. Okay, now we will again read this paragraph because this is very important. Appointment of professional by is IP. IP have to hire valuers, auditors, legal advisor, and forensic experts. Okay. Now, what is the purpose of that circular? Thus, that purpose of the circular is to promote integrity. There must be integrity, independence. That professional must be there must be integrity, and also there must be independency. Okay, that person must be independent, and the process which we adopt in CRP or in liquidation for hiring any professional, that must be transparent. Okay, and also eliminate conflict of interest. So that is the purpose of that amendment. Okay, that amendment means clarifies what to do, how to do when we are going to hire any professional under IBC. Okay, now IBBCI guidelines and circulars issued by IBBI. What was the subject? Ensuring arm length relationship in the appointment of professionals by insolvency professional. Okay, earlier we also discussed this is also very good method. Means if we will hire on arm length basis, that is justifiable. If as per market norms, if we will hire, that is also justifiable because that market base also will be more or less means similar to arm length basis. There will not be so much means difference. Okay, so much difference means if, for example, if we are calculating by arm length basis, if cost is coming X, okay, then in case of market, cost may be X plus 10% to 15% plus minus, but it will not happen. The cost difference will be more than 100%. Okay, 10 to 15% maybe. Okay, but as per this amendment, they are expecting when any resolution professional is going to hire any professional, when resolution professional is negotiating and doing calculation, that should be on the basis of arm length basis. Okay. Now, to ensure that appointments of professional made by insolvency professional, including resolution professional and liquidators, are at arm length basis, independent of the insolvency professional and corporate debtor. Independent means that person not related to IP or corporate debtor. Okay. First, at arm length basis, independent of insolvency professional and corporate debtor. And third, see, we can also see here. First, on arm length basis. Second, independent. Third, is free from conflict of interest. Number 4, not unduly influenced by personal or family relationships and in best interest of stakeholder. Okay, so means we need to ensure before appointing, when we are working in the capacity of resolution professional and liquidator, we need to see if the fees is or should be at arm length basis. There must be independency, free from conflict of interest, not duly influenced. For example, if I am working as a resolution professional, if my known person or my family relative, okay, is means referring any person, it should not happen, because all the hiring must be on the merit basis. Okay, if anyone is referring, okay, but it should be on the merit basis. Okay, but if that person, professional person, is means in relationship, in relation with IP or corporate data, so then he is not allowed to appoint. Okay, now key guidelines of the circular. We will discuss key what was the key guidelines of that circular. Professional relationship must be on at arm's length basis. Professionals such as valuer, auditor, legal consultant must not be related to the insolvency professional or to the corporate data. Okay, first, okay, means professional must not be related to the insolvency professional or to the corporate data. What type of professional we hire? Valuers, auditors, legal and consultants. Now, appointment should be made solely on merit, based on expertise, qualifications, and independence. Okay, so this is the main guidelines of the circular. Okay, the main bottom line is this: key whenever we are going to hire on merit basis, also fulfill the qualification, and that person must be expertise on this means field, for which purpose we need to hire that professional. Means if we need any technical person, that person must be expert on that technicality part. Okay, and must be independence. Okay, so this is the main key guideline of the circular. Okay, first point means we need to take a professional relationship must be on at arm length basis. That is the first point mentioned in the circular, so that that is the guideline for the resolution professional liquidator. When we are going to have, so these are the guidelines. We need to means refer these guidelines so that we can hire appropriate person. Okay, as per business requirement, and also we as per the under IBC rule and regulations. Okay. Now, second one is prohibition on hiring relatives and related parties. A professional cannot be appointed if they are a relative of the insolvency professional, a related party of the IP. Okay. Now, if a related party of the corporate debtor, in that case, person cannot, professional cannot be appointed if relative to the IP or related party to the corporate debtor. Okay. The definition of relative and related party is as per section 524 and section 524A of the IBC 201 includes. Okay. Now, there also means guiding ki what type of person comes under the definition of relative and related party. In first, second point, they are mentioning we cannot hire. Means, for example, we means insolvency professional cannot hire if that professional person is relative or related party of related party, and also related party corporate debtor. Now, question comes: who will cover under the relative and related party? They have also mentioned the list for guidelines and for the clarity. Now, if that person is spouse, immediate family members, partner in firm, director with substantial interest, significant shareholders. See here, this is the list. Okay. So with this list, we can, they have clearly defined. Okay. Now coming to third, there must be disclosure requirement. Okay, when see this is also very important. Whenever we are going to hire any professional, we will issue engagement letter. We will also take means declaration from that professional before hiring. it means that person will have to give declaration. Okay, what type of declaration that professional person need to give? Disclosure requirement. The IP must disclose the relationship status of the appointed professional with the IP himself, herself, the corporate related. Okay, we will also take declaration, but whenever we are going to hire, we will also confirm or give disclosure कि we don't have any means relationship, or he is not related to the insolvency person, and he is also not related to the corporate debtor. Okay, so that declaration must be maintained in reports and produced when called upon by any. Okay, and also committee of directors or adjudicating authority. Okay, means whenever we are going to hire, we means as a insolvency professional or liquidator going to hire any professional, we will have to see, we will have to verify, we will have to do due diligence. That person should note or must note means are relative or related party, or also related party corporate data. We will have to give declaration. Okay, that person is not related to us and not relative. We will have to give declaration. And in case of if in future, if there is any question asked, any question raised, any objection raised by any appropriate authority, means or IBBI, or in case COC, so then that documentation will help us to justify and clarify that hiring is as per the hiring was done as per under the IBC code. Okay. Now coming to the documentation. So that documentation part is also very critical and important. Okay, the appointment should be formalized through a writing engagement, written engagement. The appointment should be formalized through a written engagement or appointment letter, which clearly mentions the scope of work. Okay, if you will clearly mention the scope of, then there will not be any chance of any any means we can say that there will not be any communication gap and conflict of interest. Okay, so and also it will be clear to both sides. For example, as a IP, I will be clear ki what type of work we are expecting. Okay, and the other profession will also means clear ki what are the activities is to do as per the scope of work. So there will be clarity from both sides. Okay. Now fees we have discussed. Fees must be as per scope of work and as per on annual basis as per market base. Okay, and also duration means how much time it will take to complete this task and how much time taken to complete this task, and also review and monitoring will be done by insolvency professional on daily basis or maybe on regular basis. Okay, and also there must be a reporting structure. Okay, so that person will have to means submit their reporting. Okay, which define as per scope of work, and also other than scope of work we can also define that will be the reporting structure. Okay, means in reporting structure we can ask data as per the requirement, as per the scope of work with timeline, and that report will go to what level at what person need to share. Okay, because we at the end of the day we also need to maintain the confidentiality. So then there must be need to set up a proper process or reporting structure. Okay, includes a declaration of independence by the professional appointed. Okay, and also there is a declaration of independence by the professional appointed. Okay, also need to mention clearly. Okay, now statutory and regulatory linkage. Okay, see here. IBC section 22A permits the RP to appoint professionals to assist in managing operations. Okay. See, this is section 22A permits the resolution professional to appoint professionals to assist in managing operations. Okay, this is the section. Okay. Now coming to this is the IB section. Now coming to the CRP regulations 27 and 35. Go on the appointment of registered valuers and other professionals. Okay. This is the CRP regulations. Now IBBI Insolvency Professional Regulation 2016 7A requires independence and avoidance of conflict of interest. This is as per regulation 7A. Okay. Now, code of conduct under first schedule of IP regulation requires impartiality. There must be impartiality. Okay. That process must be means impartial. Okay. There must be integrity, independency in professional dealings. Okay. So that is the code of conduct first schedule of IP regulations. Okay. What is the impact and importance of this circular? See, the impact and importance is this. We can categorize in four categories: fairness, credibility, governance, audit, and compliance. Fairness means ensure fair competition and based hiring. Okay, that process should be fair competition means if we are offering any professional assignment, okay, so then we will give equal chance to individuals and agencies, and we will hire them on the basis of merit. Okay, not on the basis of any reference. Okay, so then that means there must be a fairness in appointing or hiring any supervision of professionals. Okay, now there must be credibility, boost confidence of COC, characters and regulators in CIRP process. Okay, in this way, what will happen when we are hiring? Means in the light of above guidelines or above circulars. Okay, so that is what will happen when there is a transparency. Okay, when we are consulting with stakeholders, so it will definitely make credibility. Okay, and also it will make confidence, and we will also be able to meet the compliance and also appoint as per regulations as per CRP liquidations. Okay. Now governance, reinforce ethical governance and accountability by the insolvency professionals. Okay. Now means when there is a transparency, when there is a reporting system. Okay. When insolvency professional is monitoring, so then it will be also it means to meet the deadlines. Okay, so then and also it also ensure the accountability of the insolvency professionals. So as per this guideline, so these are the that will be that is the main importance. Okay, now coming to audit and compliance helps RPs withstand scrutiny during audits, inspection, and COC meetings. Okay, when we are documenting all the hiring, means when we are hiring any professionals and we are documenting we what type of documents we will maintain, what was the purpose, why we hired, on what basis we hired, what was the fees. Okay, all the related documents when we will document. Okay, at the time of during audit or any inspection by IBBI, okay, and by adjudicating authority, and also by COC or stakeholders, that document will help insolvency professional to justify that hiring was done as per the means business requirement or as per the necessity. Okay, so that will be justifiable by the insolvency professional. So that circular is very important from the from the purpose of hiring any professional. Okay, so that circular provide the guidance ki what are the steps need to take care, what should be the procedure, what will be the documentation. So all those things uh, insurance person need to take care as per this circular, so that appointment of any professional can be done as per the IBC. Okay. Now, recent amendment. Okay, now practical steps for compliance by insolvency professional. Okay. This is the checklist. Okay, see here. What what are the practical steps from the compliance point of view by any professional insolvency professional need to means take care. Okay, in practically, see, number one, identify genuine need for external professional assistance. Okay, we already discussed in above. Key, first we need to check is there genuinity need for external professional. For example, if we need a technical person, okay, if already that type of technical person is in the system in the company, okay, so then we don't need to hire that technical person in as per compliance. Okay, and as per means some means there is a mandatory requirement for registered earlier. In that case, we cannot do anything. We will have to hire. But for other professionals, first we need to check is to identify the genuinity. There is a necessity. Then we will hire external professional. If we don't have such type of professional, if we have a competent professional, so then we will not hire any other external professional. So that is the first point. That is the practical steps which we need to take care, and we need to go as per means practical means term. Now, if we find there is a genuine need for hiring of external professional, then what we'll do? Then we will shortlist professionals based on the qualification, experience, and independence. Okay, means now second step will be we will need to we will means offer professionals if we need the person such like. Okay, so then when they will submit their applications, okay, so then we will shortlist professionals based on the qualification, experience, and independence. Okay, but I will also add here the shortlist professionals based on means scope of work, okay, and task for what purpose we need a person, okay, and aligning the same with qualification, experience, and independence. Okay, now third, obtain declaration of no conflict, no relation to IP or CD. Okay. See, we will also ask take declaration from that professional key that professional don't have any relationship with IP or he is not related party to IP or related party to corporate data and there is no conflict of interest. Okay. He will have that professional will have to give declaration. Okay, and in case if found in future he has given wrong declaration, then appropriate legal action can be taken against that professional and as well as on the appropriate action against insolvency professional. So then that means it doesn't mean the resolution professional is taking declaration, then he is also responsible. Okay, if he knows he is related party and he is in the relation of that professional in relationship, so then he should not hire that person. Okay, now coming to fourth point. These are the practical steps we take when we are in the process and we are going to hire any professional. Okay, now coming to the compare cost. Then we will compare cost. If we have applications, say for 5 candidates, 5 individuals or 5 firms, then we will compare the cost. Okay, and negotiate fair fee arrangement. Okay, okay. That fees must maybe on the basis of arm length, maybe on the basis of market base, but we will first compare cost and negotiate. Okay, and also we will maintain that document. Okay, because that document will help us to take approval from COC. Okay, and in case of any audit, any inspection, or from IBC or adjusting authority, we can means justify and also provide that base document. Okay, now after all those 4 steps, our fifth point will be formalized agreement, engagement letter through a written content. Okay, first there is a genuine need. We know we will shortlist profession as per scope of work. Qualification, experience, and independence must be aligned with that scope of work. We will take declaration from that professional person. We will compare cost on the basis of arm length or market basis. Then, after these 4 steps, when everything is okay, okay, so then we will go for next step, formalize engagement through a written contract. Okay, because there must be a written contract in which we will clearly mention the scope of work, fees, timelines. Okay, we will mention clearly so that in future there should not be any conflict of interest, any confusion. Okay, if everyone is know what will be the scope of work and at what time the deliverable is to meet the deadline, so then there is no problem. Disclose appointment in COC meeting and record minutes. Okay, then after this, all the related documents, okay, in COC meeting, okay, for the purpose of approval, okay, and for the purpose of further step. Okay, so then we will disclose these appointments so that all the appointments must be transparent and have the confidence in the COC members and the stakeholders, and also record the minutes. Okay, so that is very important from the compliance point of view. Okay, maintain complete reports for inspection by IBA and adjudicating authority. When we have taken approval, okay, so then all the related documents, then we will maintain all the complete reports. Okay, which will helpful for us in case of inspection by IBA or any means or by adjudicating authority. So this is the practical step we need to take care. Yeah, we have to take. Okay, I think this is clear to everyone, because unless until we will go for first step. Okay, so then if we can also make flow chart. For example, if this is coming yes, so then we will go for second step. Okay, so these are the main 7 steps we have to take before hiring any professional. Okay, now see, now we have also, I'm also sharing example clause for engagement letter. The professional affirms, the declaration will be given, the professional affirms that the declaration will be given by the professional. So now this is the example clause, okay, for engagement letter. The professional affirms that they are not a related party of the insolvency profession or the corporate debtor, and they are acting independently and at arm length basis. Means fees is considered on at arm length basis, and any conflict or potential conflict must be disclosed immediately in writing. Okay, that is the means example clause. Okay, for the purpose of engagement letter. Now, conclusion. The IBBI circular dated is a cornerstone directive that reinforce ethical practice. Okay. Now that circular reinforce the ethical practice means practical that should be the ethical practice. Okay. Now transparency should be there. Independency should be there in the conduct of insolvency professional under the IBC. It also ensures that professionals engaged during insolvency are not only qualified but also free from the bias and influence. Okay, see here, this is also very important. It ensures that professionals engaged during insolvency are not only qualified, okay, but also free from bias and influence. Maintaining the sanctity and credibility of the insolvency profession. So that is the conclusion of that circular. Means it focus that means amendment focus on the ethical practice, transparency and independency. Okay, and also fairness, and also it creates the credibility during the insolvency process, during the CRP and liquidation process, because when we will do as per these guidelines, as per these circular guidelines, so then there will be chance, there will be minimum chance for any miscommunication. Okay, means we will take appropriate action according to this, and then we will be able to do compliance under IBC. Okay. Now, see, we can also quickly understand what are the provisions which we discuss here for the purpose of ready reference. Okay. This is summary table. We discuss section 22A CIRP. IRP can hire professional to preserve asset value. Okay, because in this situation, we do CIRP on the basis of going concern basis. Okay. Now section 225 2D RP to hire as a needed for resolution process. Regulation 27 IRP may appoint based on the needs and skill. Regulation 7A say CIP fees for professional must be reasonable. These were the regulations. After these regulations, means circular issued in IBB circular issued in here, see here, in 16 July 2018. Okay, all these regulations was there in the act. Okay, now after this act, the amendment came into picture through IBB circular on 60 January 2018. Okay, now section 30. Now these sections were main sections were pertaining to the CIRP. Now these sections are pertaining to the liquidation, and after this judgment, means this circular applicable. Okay, so see here, there was a provision under section 35 1C liquidation. Liquidator may appoint to assist in liquidation. There was a regulation 7 liquidation appointment protocol records and independence. Section 30 says liquidation says stakeholder consultation, not binding advice. We discussed above. Regulation 34 liquidation fees as a liquidation cost priority in distribution. So these here summary we can say. Okay, so these sections provisions were related to liquidation, and these sections are pertaining to the CRP. Now after this IBA circular in January 2018, this is applicable to all. This guidelines on engagement main focus are on arm's length basis and no conflict of interest independence. Okay, so the focus was on how to hire and what how to decide fees. So the focus and proper guidelines means clarified and clearly mentioned in this circular. Okay, and this is applicable to all, means in CIRP and liquidation. Okay. Now, there was another amendment done by IBA circular through dated 12th January 2018. Okay. And that was the title was retention of records relating to corporate insolvency resolution process. Okay. Provides clear guidance to insolvency professionals, especially IRP and other professionals, on how to maintain records on of decisions and actions, including hiring of professionals taken during CIRP under the IBC code. See, above circular focused on guidelines on engagement, okay, and key requirement was on arm's basis and no conflict, okay, independence, etc. Now, this circular focus on maintaining records. See here, circular detail, date of issue 12th June 2018, circular number IBB CIRP 0082018. Subject was retention of records relating to CIRP issued by IBBI. Okay, see here. So means that circular focus on how to maintain reports of decisions and actions, including hiring of professionals taken during CRP and okay. So here this amendment is mainly focusing on documentation part. Okay. Means retention of reports relating to CRP. Okay. Now,
Sir, sorry for the interruption. Actually, please take 10 minutes for tea break. Okay. It's
yes, yes,
around 1.5 hours actually.
yes, we
So
can
please
take
take 10 minutes and all others also take 10 minutes for tea break. Okay.
okay, no problem.
Okay, sir.
We
Thank you,
can
sir.
start of 4:30.
Yes, sir. Yes, sir. It is 4:30 now.
Okay,
So
okay.
we will start by 4:45.
Okay,
4:40.
thank you.
Okay, sir. Thank you. Please, dear all, please take your tea time and we
Okay.
will meet once again by 4:40 or 4:45. Okay. Thank you, sir. Please take break. Thank you, sir.
Hello.
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 There is no audio, sir.
Sir, actually, this is a tea break actually. So from 4:45 onwards, the session will continue. Thank you, sir.
Okay, now we can start.
Yes, sir.
You can start, sir.
Okay. Okay. Now that was a second amendment. Okay. Was issued by IBBI on 12th June 2018. That circular was more related to the retention of records relating to the CIRP process. Now, what was the objective of that circular? To ensure that proper records are maintained of all actions and decisions taken by IRP, RP during CIRP. Okay, these records are retained for accountability, regulatory scrutiny, legal audits, and for reference in legal proceedings if required. The hiring and supervision of professionals, among other CIRP related decisions, are well documented and transparent. So that was the objective of that circular. Main objective of that circular was to maintain the proper record. Okay, so that in future, in case of any requirement, means for the purpose of audit and scrutiny and accountability, so that document can be referred, okay, during legal proceeding and as well as audit by audit and also means scrutiny and audit by IBBA or any means and educating authorities. Okay. Now coming to the key provision of that circular, the IRP must complete record of all decisions taken during CIRP. Procedure followed for taking such decisions, reason of rationale for such decisions. Number 3, supporting documents such as email, letters, minutes, resolution and approvals. Okay, means resolution professional will maintain a complete record when decisions taken during CIRP. What was the procedure followed for such decision? Reason for such decisions. Supporting document. Supporting document maybe we can include emails, letters, minutes, resolution, and approvals. Okay, so these are the supporting documents when we are maintaining records of documents. Now, these includes decisions relating to hiring of registered valuers, legal consultants, forensic auditors, transaction auditors, and other professionals, like public announcements, constitutions, COC, evaluation of graduation plans, issuance of expression of interest, voting decision by COC. Okay, so these decisions are also related to. So these are the types of decisions which we take during CIRP. Now, scope of record keeping, hiring professionals. Okay, selection process. What was the selection process? Criteria used: independence declaration, engagement letter, COC approval if applicable, fees details. So these are the decisions taken by IRP or IRP, hiring professionals. Okay, now second one is CRP related resolutions, minutes of meeting, voting records, decision by IRP, IRP, communication with stakeholders, copies of notice, circular emails and correspondence, transaction audit or avoidance proceedings, appointment letters, reports, and follow-up action, resolution plan evaluation, expert opinion, sort evaluation matrix, use scoring sheets. So these are the decision types, and we need to maintain documentation, required documentation. Okay, so these are the guidelines given through this circular. Okay, so means what type of documents are required we need to maintain, and normally we have to take decisions during CIRP. So these are the decisions normally we have to take, and so these are the documentations record we have to maintain. Now, what will be the retention period? This is very important. The IRP RP must retain the records for at least 8 years from the date of completion of the CIRP. or conclusion of legal proceedings, whichever is later. Okay, in anyhow we have to maintain the records, and we have to keep these records at least 8 years. Okay, if there is a legal proceedings going on, and after 8 years, so then we have to also maintain till the legal proceedings concluded. Okay, so means if there is no legal proceedings, we have to maintain that record, we have to retain that record at least 8 years. Okay, the long retention period is to ensure that records are available in case there is a regulatory inquiry, court of NCLT litigation arises, IBBI inspection, or disciplinary proceedings are initiated. Okay, so normally we have to keep these records by 8 years. In case of any legal case, any disciplinary action, any inspection, okay, if taking more than 8 years, so then we'll have to maintain that, keep that record till that query or legal proceedings concluded. Okay, purpose behind the requirement. What was the purpose? The circular underscores the following objective. There should, for the first purpose of transparency, just why and how decisions, especially about hiring professionals, were taken. Okay, so whenever any circular is issued by any authority, so there must be a purpose. For this circular, purpose was that there need to maintain transparency, accountability, audit trail, or dispute resolution. Transparency, justify why and how decision, especially about hiring professionals, were taken. Justification, first there must be a transparency. Number two, there should be a justification on what basis and why we means for first question comes, why we hired, is there necessity, is there requirement? If we hired, is there any necessity? Okay, there was a requirement, so what means what was the procedure adopted? Means there should be need to maintain the transparency, and there is a accountability. Ensure IRP, RP perform the role with diligently and can defend their decisions. And who will be the accountable? Audit trail, facilitate inspection or audit by IBBA or educating authorities, and in case of any dispute, provide evidence in case of future litigation or challenges. So then the related document or relevant document can be produced for the purpose of justification and to solve that resolution in case of any dispute, and for the purpose of any audit or any means inspection by IBBI, so we can provide that detail or base document to justify. Okay, so that was the purpose behind the requirement for issuing that circular. Okay. Now, now the circular directly impacts how IRP and IRPs engage professional under IBC. Hiring decision must be documented, includes minutes of meeting, reason for choice, comparative proposals if obtained, and engagement terms. So these hiring decision must be documented. Means we will include in these things we will include. Why we have taken this hiring decision, and if you have taken hiring decision, so what was the base and what was the rating documents? So now maintaining due diligence reports means independence declaration, arm length confirmations, and professional credential must be stored. Okay, so maintain due diligence means before hiring, IRP have to do due diligence. Okay, and also take independent declaration, and we need to negotiate fees on arm length basis as per circular dated 16 January 2018, and professional credential must be stored. Okay, now fees and scope clearly mentioned engagement letter must be detailed scope, deliverable, time frame, and fee structure. COC involvement where necessary, decisions requiring COC approval should be supported by voting reports and justification. Okay, so these are the implications for hiring and supervising professionals under this circular issued. Okay, and directly impacting RP or IRPs engaging professionals. Okay. Now, what should be the checklist for record keeping? Earlier we discussed checklist for hiring. Now, this is the checklist for the purpose of record keeping. What type of documents we need to document it. First, engagement letter, independence declaration, minutes of COC, proposal evaluation, justification memo for appointment, fee approval note. For example, if we have taken approval from COC, so then fee approval note, correspondence with professionals, deliverable and progress reports, final bills and payment proof, retention of records for 8 years. Means this is the checklist for your ready reference for the purpose of record keeping. So these are the documents we need to keep up to 8 years, or in case of any case is going on. So whatever is later, so then we have to keep the records. But these are the documents we need to maintain as per these IBBS circular, as per these guidelines. Okay. Now conclusion. The IBBS circular dated 12th June 18 reinforced the need for transparency, accountability, and meticulous record keeping by IRP, RP under the IBC. When it comes to hiring and supervising professionals, every step must be documented, reasoned, and retained to withstand regulatory and judiciary scrutiny. Okay, so that was the conclusion. Okay, means conclusion was that hiring was transparent and clearly mentioned the accountability. Okay, and clearly mentioned key time period for record keeping that record. Okay. Now we will discuss the sample engagement letter. Okay, when we hire any professional, so what key clauses we need to mention in the engagement letter or contract letter. So this is the sample engagement letter. First, on the letter of the resolution professional, date, to name of the professional or professional firm, address, subject, engagement of professional, in which capacity, registered valuer or forensic auditor, whatever the capacity in which we are going to hire, that will be the subject. That I full name is resolution professional of corporate data, appointed under the provision IBC code, means hiring the such type of professional. What we will cover? The engagement letter, the terms of engagement are as under scope of work. Okay. See, when we are hiring forensic auditor, the examination of financial reports of identification of professional, preferential, undervalued, fundamental. Okay. Examination of financial reports for identification of preferential, undervalued, fundamental or extraordinary transactions under section 43 to 51 and 66 of IBC. So then we will clearly mention the scope of work. Okay. So under the scope of work, so when we are hiring forensic auditor, so we will clearly mention the scope of work. Okay. If we are hiring registered valuer, so we will take the determination of fair market value, liquidation value of the assets as per valuation. So we will clearly mention what type of professionals we are going to hire and what will be the scope of work with deliverable timelines. And now point number 2 will be reporting timeline. Draft report to be submitted within days of appointment, final report to be submitted. Okay. So then we will clearly define the timeline. Number 3, we will also cover the professional fee for the assignment shall be this plus taxable and out of expenses. So we will clearly mention the fee structure. Point number 4, confidential. You are required to maintain strict confidentiality and shall not disclose any information to any third party unless authorized by the IRP or required by law. Okay. Point number 5, professional standards. You shall adhere the code of conduct and standards as prescribed by IBB and applicable laws. Termination, the engagement may be terminated by either parties given notice, subject to completion of work already undertaken. Okay, so these are the main clause which we need to mention. This is not means we can also means mention all the other clauses as per the requirement, but these are the main clauses which we need to take care, definitely mention, so that we can uh, cover all the clauses to meet the compliance as per the IBC. Okay, now checklist for RB's hiring and supervision profession. Identify need. We have already discussed. For example, determine the need for forensic evaluation, legal or technical express based on CRP complexity, whether we need that person or not. And we will check the eligibility. Ensure professional are registered with IBBF in case of valuer. Meet ICAI, ICSI or ICOAI norms. Scope of work, clearly define the scope of work. Fraud detection, valuation, legal opinion. Whatever the activity which we are giving and for which purpose we are hiring. So clearly we need to mention the scope of work. Obtain COC approval while hiring RP's discretion. Major posts must be placed before COC for approval under CRP post. Formal engagement letter. We need to issue formal engagement letter with scope, fees, timeline, and confidentiality clause. Confidentiality agreement, get a note NDA. Okay, we can also go for an NDA. Okay, separately if needed. Timeline and milestone, we will clearly mention monitor and deliverables, supervise work regularly and ask for draft reports, clarification, maintain reports, keep all communication, invoice, engagement letter reports and feedbacks in CRP reports, report to COC, share professional reports and explain impact, valuation, fraud finding, and in COC meeting, evaluate performance, post assignment, evaluate whether objective are met and document performance. So these are the checklists for your ready reference. Okay. Okay. Now we will discuss major case laws. Okay. Now we have covered all the relevant laws and circular issued by the IBBI. Okay, we have discussed in detail. Now we will discuss the relevant judgments. So in the light of the judgments, we can understand if in case of if any situation comes, then how to deal. Because earlier judgment guide us in case of any similar issue or concern comes during the CIRP or liquidation. Okay, so these are the very relevant judgment, very good judgments. See, there was a judgment, Supreme Court judgment in Sundaresh Bhatt Liquidator of ABG Shipyard Limited. Okay, this is the case with the Custom Department. See here, civil appeal number. That bench was this. Date of judgment is 26 April 22. Background of the case, ABG Shipyard Limited was admitted into CRP process. Later proceeded into liquidation under IBC. Okay. Certain imported goods were laying in custom bonded warehouse for which custom duty was unpaid. Okay. Now, in case of liquidation, the liquidator, Mr. Sudarshan Bhatt, sought release of these goods without payment of custom duty on the basis of Section 14 moratorium and 33 initiation of liquidation of the IBC. For example, if any company is normally doing business, okay, all of a sudden, if company goes into the liquidation and if liquidator appointed, okay, in case of CIRP or in case of liquidation, you know, moratorium starts. Okay, this is the case where duty not paid. Now, if that firm is into the liquidation, so then question arises: if a liquidator can take back these goods or not. So this is the case. Okay. Now, the Custom Department refused sitting powers under the Custom Act and sought to recover custom dues, because when liquidation starts, so RP, liquidator asked to release the goods without payment of custom duty on the basis of Section 14 moratorium start and 33 initiation of liquidation of the IBC. Under these act sections, because IBC override all the other acts. So in that capacity, he asked to for the goods, but custom department refused. Now issue before the Supreme Court whether the custom department can retain goods of the corporate debtor, recover duties during moratorium liquidation, whether liquidator or professional can demand release of goods without payment of dues. Okay, now another question was how hiring and supervision of professionals, including liquidator, operates within the IBC in relation to statutory authorities like customs. So that was the question. Okay, asked by now. See here, what was the relevant provision? First, we need to discuss this. IBC Section 14, moratorium during CIRP. IBC Section 33(5), bar on proceeding post liquidation. IBC Section 35(1)(b) and F, duties of liquidator to take custody and control of assets. IBC Section 238, overriding effect of the IBC. Okay, this is also very important. Okay, Regulation 7 and 8 of the liquidation process. Regulation allow hiring of professional by liquidator. Now, as per Custom Act, Section 72 and 110, seizure and laying powers of customs. So these are the relevant provisions related to this case. So for your ready reference, I have mentioned here these relevant provisions. Okay. Now, what was the Supreme Court observation? IBC has overriding effect. The Supreme Court held that once CRP liquidation commences, custom cannot enforce recovery actions for dues under the Custom Act, because when liquidation starts, okay, so then means other, or in case of CRP, whether that is income tax department or custom department, any other government department means can submit the claim as the operational guide. Okay. Now, IBC being a complete court overrides any constitutional provision of the other laws. So that was objection given by the Honorable Supreme Court. Now, number 2, goods must be handed to liquidator. Customs was directed to release the goods to the liquidator without insisting on custom dues. The liquidator must be given full possession and control as per Section 35(1)(b) of IBC. Okay, so that means this was the case when normally in case of without paying custom duty, custom department will not release the goods, but when moratorium starts, okay, so then other act, IBC override other acts. So in that case, that department cannot hold the goods. They will have to release the goods because moratorium starts. Okay, now another question: role of professional hiring and supervision under IBC. In this case, appointment and authority of the liquidator. Sudarshan Bhatt was appointed as liquidator under IBC as a licensed insolvency professional. As per Section 34, appointment of liquidator of IBC RP during CRP becomes the liquidator unless replaced. The liquidator is hired and supervised under the statutory framework of IBC regulations and approval of COC and NCLT. Okay, so another was statute duties of the liquidator. Under Section 35 of the IBC, liquidator is empowered and obligated to take custody and control of all the assets, property, and actionable claims. This is the duty of the liquidator as per Section 35. Investigate financial affairs of the corporate debtors. Okay, hire registered valuers. So this is the duty of the liquidator. Hire registered valuer, legal professional, and other experts to assist in liquidation. Ensure that liquidation is done in a time-bound, transparent, and maximize value manner. Okay. So these were the observation given by the Honorable Court. See, hiring of other professional to ensure release and valuation of goods, the liquidator may have hired legal counsel, valuers, logistic professionals, chartered accountant, tax consultant. Means he can also hire another professionals. Okay, for to release these goods. Okay. Supervision and accountability. All professionals hired to be supervised by the liquidator. The liquidator is himself subject to regulation by IBBA and is required to maintain transparency and record of hiring, justifies expenses incurred in hiring, Regulation 7 and 8 IBBA regulations, subject periodic report to the adjudicating authority. What was the key takeaways? Key takeaways for this case: reinforce IBC supremacy, clarifies that statutory authorities, including customs, cannot obstruct liquidation. Okay, means in case Custom Act and IBC Act is there, so IBC Act will override the Custom Act in as per this judgment, and not as per this judgment, in actually empowers professionals, strengthen the legal backing for insolvency professionals to take control of assets and hire experts to add liquidation. Clarifies government roles. Custom must act as an operational character. I already asked you to custom department or income tax department. Now they will act as the operational character and file their claims rather than unilaterally recovering dues. Sports efficient resolution. Liquidation must work with hired professionals to ensure speedy and fair liquidation. The judgment not only affirms the overriding nature of IBC, but also validates the authority and functional independence of insolvency professionals like liquidators, including their power to hire, supervise, and coordinate professionals during insolvency proceedings. It is a landmark case in the effective implementation of the liquidation process under IBC, ensuring assets control, claim transparency, and legal control. Okay, that was the first case judgment given by the Supreme Court. Okay, so that is very means landmark judgment in case if any government authority have any asset or any goods, okay, so then they cannot hold after moratorium starts. Okay, so they will have to means give back to the insolvency professional or liquidator, so then they can also file their claim as a operational matter. Now coming to the second case judgment, also given by the Honorable Supreme Court. That case was between SR Steel India Limited versus Tishwar Gupta. Background: a large corporate debtor underwent CIRP. The RP was Tish Gupta, and SL Mittal submitted a resolution plan which was approved by the COC. The company law appellate tribunal modified the resolution plan by redistributing payment to operational creditors and altering the commercial wisdom of the COC. COC challenged the NCLT order before the Supreme Court, arguing that the commercial wisdom of the COC should be final and that the resolution professional cannot alter it. What was the legal issue came into the picture? Whether the commercial decision of the COC can be interfered by the A authority, what is the scope of RP, how hiring and supervision professional by RP should function under the IBC framework. So what was the relevant provisions for this case? Section 18, duties of IRP, Section 20, management of operations, 25, duties of RP, Section 20, replacement of RP, Section 30, submission of resolution plan, 31, approval of resolution plan, Section 20, function and obligation of insolvency professional, Regulation 3, appointment of professional by RP, Regulation 27, appointment of registered valuer. So these are relevant provisions related to this case. Now, what was the key observation of the Supreme Court? Role of the RP. RP is not an educator or a decision maker, but a facilitator of the insolvency resolution process. Okay. His duty is managing corporate debtor as a going concern, inviting claims, consulting, and convening meeting with COC, assisting the COC in evaluating resolution plans. The RP is only a facilitator and not an educator in the CRP. He is expected to act professional and independently without bias. So that was the key objection given by the Honorable Supreme Court. Hiring of professional by RP. Supreme Court emphasized that RP's role in appointing qualified professionals such as value legal advisor. These professionals assist the RP in forming and inform the opinion on the viability of the resolution plans and managing the debtors affairs efficiently. Okay. So the professional hired must be independent, conflict-free, and registered with the IBBI. Third one was the supervision and accountability. IRP remains the personal accountable. Okay. If any professional fails to perform, RP must take corrective action, including replacement. And how he will be accountable, ensuring the integrity of the process, monitoring the deliverables, and reporting to the COC and adjudicating authority. Okay. Because he is accountable for to the COC and adjudicating authority, because he will have to monitor the deliverable given by the hired professionals. Okay. Now, COC, commercial business, the court reinforced primacy of COC, commercial decision, and held that RP cannot interfere or modify the decision. NCLT cannot alter commercial terms of an approval plan. It violates the law. Okay. Present Act, the judgment draw a clear boundary. RP is a facilitator, not a judge. Professional technical support of not decision maker. Practical implications, due diligence. RPs must exercise care in hiring experts or valuation and any other professionals. Transparency, RP must document and basis and process of hiring professionals. Okay. And that process should be cost efficiency. Okay. What was the conclusion? Conclusion was RP act as a coordinator. Hiring of professional is a critical component of managing CRP. While professional provide technical inputs, RP retains supervisory control and responsibility. The case reinforces the transparency, diligence, and neutrality in hiring and supervising professionals are crucial for the credibility of the IBC process. Okay, so that was the judgment given by the Supreme Court. Okay, now coming to the third judgment given by the Honorable NCLT. That case was Wellspoon versus Liquidator. What was the background? ABG Shipyard Limited, a major shipping building company, went through CRP. After no viable negotiation plan was approved, the company entered liquidation. Then Wellspoon Steel Resources, a prospective buyer, during liquidation submit a bid for some assets of ABG Shipyard. Dispute arose when the liquidator rejected the bid, citing non-compliance and procedural lapses. Okay, now issue before the NCLT. What was the issue? Whether the rejection of the bid by the liquidator was valid, whether the process adopted by the liquidator was transparent, fair, and compliant. What was the scope of liquidator's decision? How should professional be hired and supervised during liquidation? So these were the issues before the NCLT. So these are the limit judgments, means sections. Section 35, we have discussed. Section 208, function of and responsibility of insolvency professional. Regulation 32 to 38, manner of sale, auction process, valuation and marketing. Regulation 7 and 8, hiring and remuneration of professionals by the liquidator. Section 238, overriding effect of the IBC. Now, what was the key finding by the NCLT? Liquidator role is statutorily defined. Okay. Liquidator is independent professional empowered to act in the interest of the stakeholders. Okay. Hiring and supervision of professional is empowered under the IBC code. Okay. He can hire valuer, legal advisor, transaction auditor, and auditors. So he can hire and supervise the professional under the IBC code. Due process and transparency, he need to maintain, he will do all the hiring and professional supervise as per due process, and there must be transparency. Rejection of bid was valid. The liquidator acted within his discretion, okay, as per the IBC Act. So in that case, if decision taken by liquidator is valid, okay, if this is in the interest of the stakeholders, okay, the liquidator acted within his discretion, following the advice of appointed professional and in the best interest of the stakeholders. In that case, if Westwood bid was not found non-compliant with the sale terms, okay, so when that was non-compliant with the sale terms, so then he can take decision. Now, emphasis on hiring and professional under IBC. Hiring. Regulation 7 and 8, liquidator can hire professionals. Supervision, he can also supervise the with professional. Compliance and value maximization. Hiring of professional must be cost effective and aligned with the objective of maximizing the value of the debtor's assets. In this case, the professional value advisor guided the sales strategy, which was followed by the liquidator to reject subpar bids. What was the takeaway? Liquidator acts as a fiduciary for all stakeholders and must ensure value maximization. Professional hired under IBC must be registered, competent and supervised diligently. The role of such professional is interest in asset valuation, legal compliance and sale execution. Okay. The liquidator's action, if aligned with professional advice and regulations, enjoy judicial protection. Okay. So then what was the conclusion? Reinforce the importance of a liquidator's independence and professionalism under IBC. Highlights the critical role of hired professional. It ensures fair, transparent and value maximization liquidation process. The judgment validates that so long as the liquidator decisions are based on experts' inputs, follow due process, and align with statutory guidelines, they are not open to judicially interference. Okay, means if there is a non-compliance by bidder, so if decision is taken by liquidator in the interest of the stakeholders, okay, so then this decision is valid. And now another case is between versus Axis Bank versus Aju Camp Infrastructure and School Management Limited. Background was filed an appeal before the NCLT against the decision of the NCLT New Delhi. Was admitted in Section 7 under IBC, initiated CRP against cases. Axis Bank had concerns over the implementation of the CRP, over the hiring of professionals, their course and supervision under the resolution professional. Okay, that what was the key issue? What is the scope and discretion of a RP to appoint professional during CRP? To what extent COC supervise and approve the engagement fees of such professional? Is there judicial oversight on the quantum and necessity of the professional appointments during CRP? That was the key issue in this case. These were the relevant sections, section 22. These sections we have already discussed above also. What were the observations and findings of the NCLT? Autonomy of RP to hire professionals. Okay, that is given. RP must act in a time-bound manner, therefore must be equipped to engage professionals for valuation, legal analysis, forensic auditors without awaiting COC micromanagement. Okay, so he has the empowerment to appoint professionals to assist the CRP or liquidation process. Okay, so that observation was given by the NCLT. What is the role of ROC? ROC can question with the reasonableness and quantum fees, but cannot interfere in who is hired and how the professional operates, unless clear abuse of discretion is evident. The RP must report all such appointment related costs to the COC for transparency and financial control. COC is not expected to approve each hiring beforehand, but must be kept informed and aligned with the court implications. Okay. And for accountability, NCLT emphasized justified by work done. Emphasize that professional fee must be justified by work done, supported by documentation, reasonable and benchmark. Any unexplained escalation in professional costs or duplication of services may attract COC objection or judicial scrutiny. The role of professionals hiring during CRP in this case. Hired registered valuer. Okay, so he can hire professionals during the CRP case. What was the impact? The CRP was complex due to multiple subsidies, cross-holding, and ongoing litigation. The RP's ability to quickly appoint professionals allowed faster turnaround of asset valuation, litigation review, preparation of information and resolution plan evaluation. Now, legal significance and earning. Principal application, operational independence of RFP can appoint professional based on case needs without COC prior consent. Okay. Now, related case reference was given SR Steel India Limited versus Tish Kumar Gupta, RP of Care Office Equipment versus Hemant Sharma. So these are the related case were referred in this case. What was the conclusion? NCLT reinforced that while hiring professionally is essential for resolution, it must be done with the transparency, accountability, and cost justification. The RP must supervise and manage the engagement, and COC must exercise financial oversight without interfering the operational domain. In the similar NCLT case between Majatamba Tubes versus Quality Sales, okay, the key issues were here mainly the case highlighted concern regarding the appointment and oversight of professionals by the RP and during CRP. So these were the key issues related to supervision of professionals. NCLT observation was there should be a record keeping or note, arm length appointment, supervision of accountability. These were the NCLT observations. Means arm length basis as per the circular issued on 16 January 2018 by IBBI. Okay, record keeping as per the 12th June 2018 and supervision of accountability. These were the NCLT observations. Now, implications of this judgment: enhanced due diligence, transparency in CRP course, adherence to IBA guidelines. So these were the implications. Okay, so these are the implications. Now, last case was between Ganesh Maralal versus Mamta Binani. Okay, the key issues was admission of workman's claims, updating the list of creditors. Okay, these were the key issues addressed. Okay, now NCLT observation, role of the resolution professional, supervision of professionals, compliance with legal orders. Okay, so these were the NCLT observations. What was the role of observation? The terminal emphasizes the RP's duty to verify and admit claims submitted by creditors, including workmen, in a fair and transparent manner. Okay, so this is the role of the resolution professional. And regarding supervision of professionals, the NCLT highlighted the importance of the RP roles in supervising professionals appointed during the CRP and liquidation process. Okay, the RP must ensure that all the appointed professionals act in the best interest of the CRP and maintain transparency and integrity. And also compliance with legal orders. Okay, the tribunal noted that the RP should comply with orders passed by the competent legal authorities such as the industrial court and reflect such directions in the CRP, including updating the list of creditors. So these were the NCLT observations. Okay. So implications: enhance the accountability, transparency in CRP proceedings, supervision of appointed professionals. So these were the implications of on this judgment. Okay. Now we can see here, enhance the judgment reinforce the accountability of RPs in managing the CRP, particularly in the verification and admission of claims submitted by various stakeholders. And what was the transparency? By directing the RP to update the list of creditors in the line with the industrial court's order. But regarding hiring and supervision of professionals, that was the implication. Supervision of appointed professionals. The case serves as a reminder that RPs must diligently supervise the professionals they appoint during CRP to ensure that their actions align with the objectivity of the insolvency process and uphold the principle of fairness and integrity. So that was the implications under this judgment. Okay, the main crux is this: means resolution professional liquidator can appoint professionals they have empowered. Number one. Number two, in case if there is another act, IBC override and liquidator or means RP can take back that property or assets when moratorium starts. Okay, so with the help of these judgments, we understood these things. Now, if you have any question, please let me know. Otherwise, we can conclude this session. If any question you can ask, otherwise we can close this session.
Sir, actually, I want to ask here a very good question here. The CARP process in final stage, actually preparing information memorandum stage, but the financial creditor is not cooperating, even though the Honorable NCLT ordered to immediate remuneration to the RP fee. They are not responding. Then what the resolution professional to do in the at this case?
Then in that case, now you can approach to NCLT and ask for direction.
Sir, already NCLT given the order to pay the remuneration, but the FC is not listening to the order also. They are delaying more than 48 hours. The
So-
NCLT has given immediate payment of the RP fee in the order itself. The order was dated 26th May and it has been uploaded in the website by 3rd June itself. But the financial creditor is not paying till today. It is 5th, 48 hours after the order.
I agree with you, but in that case, no, you are not responsible if financial creditor is not listening. So then adjudicating authority will have to take action. If he is not listening, you can means you can also again approach to the adjudicating
Contempt.
authority.
I think RB has to file a contempt of the court order.
Yeah, you can also, when you will report to the adjudicating authority, na, so then he will take a legal as per action, contempt of court. That is in the preview of the NCLT court. You can
Yes, sir.
you are only responsible to inform to means adjudicating authority.
Yes, sir. Yes, sir.
If what type of action they will take, it depends on the means honorable court. But you have
Okay.
done at your end. Now this is not the problem at your end. This is problem at the end of the financial creditor. You can only inform whenever the next date you can request to the adjudicating authority ki after as per means order also not provided this thing. So that honorable court will take
Okay,
definitely
sir.
action.
Understand, sir. Another question is, instead of paying the fees, they want to change the resolution professional immediately without COC, and they are approaching the Honorable NCLT, but this application is filed under Section 10 by corporate debtor, not by the financial creditor. Is it allowed as per law? This application is filed under Section 10, not by financial creditor. Okay, they are approaching Honorable NCLT without COC. They want to change the resolution professional as on their own to claim their illegal and fraudulent claim of 42 crore rupees. Is it possible? Is there any case study in this scenario?
No. In that case, means I couldn't get you. You are
The issue
working
is
as a
here, to
RP.
claim the fraudulent amount, they are appointing a new RP instead of a existing RP.
For example, if they have any evidence, okay, so then they can approach to the authority. If they don't have any any evidence or any
No, sir, no disciplinary proceedings against the RP, sir. RP is perfect and he has a perfect AFA and he is perfectly handling the CIRP process.
That's why I'm telling you that in that case, NCLT will take appropriate action.
Yes, sir. Yes, sir. Then the court has to decide. But the application is not allowed in the initial stage itself, as per law.
See, I'm telling you on the basis of merit, all the basis of all the facts. For example, if they are submitting false things, so then court will see. So then court will take appropriate action.
Yes, sir. Yes, sir. And you are telling that it is up to the decision of the Honorable NCLT.
Yes.
Am I right or not?
Yes, you are right.
Okay, sir. But even if the NCLT decided, it can be appealed through NCLT as well as Honorable Supreme Court, I think so. This is my suggestion to the all RPs and IPs, whoever working perfectly. If any problems, you can very well approach NCLT if NCLT is not favoring, and you can very well approach Honorable Supreme Court. The Supreme Court will favor you. Finally, even after 2-3 years also. There are many case studies are there. Please go through and this is my suggestion. Thank you very much for excellent explanation from Rajinder Kumar. Thank you, sir.
Thank you. Thank you very much.
Thank you, sir.
Thank you.
I think if there is no questions, you can finish your session, sir. It is already 5:35.
Okay, now we're closing. Hi, Anjali. Are you there?
Yes, sir. Can we conclude now?
Yes, we can conclude.
Yes,
Yes,
thank you very much, sir.
much, sir,
Thank you.
for giving such a nice session. Sir, you are requested to please share the PPT of the session.
Sure, sure, sure.
Anjali Gupta, thank you very much for arranging this kind of nice session on behalf of all IPs.
Good
Thank you.
evening,
I am
Anjali
Madhuveli
ma'am.
Nagarajan.
Anjali ma'am, good evening.
Good
Yes, sir,
evening, sir.
you can close.
Yeah, I have to write in chat box regarding diploma attendance, or it will be automatically recorded in your system. Hello.
Pardon, sir?
Should I write my details in chat box, or automatically your attendance will be recorded? This is Umesh Sahu.
Sir, it will be recorded.
Actually, I will send a Umesh Sahu. I'll chat it.
It will be automatically be recorded. If you want, you can write.
Yes. Because sometimes my system is showing different name. Therefore, okay, fine. Thank you, madam. Thank you, sir.
Thank you. Okay, bye.